Thank you, Kenneth. Good morning, everyone. Welcome to our latest presentation at Cordell Cooperative Extension's Consumer Issues Program. As Kenneth mentioned, I'm Mike Danaher. I'm an Assistant Attorney General with the New York Attorney General's Office. In Binghamton is my office, and we cover the Tompkins County region. We've been doing this a really long time, and I'd have to say that out of all the programs that we do, the landlord-tenant rights and responsibilities is the most widely attended. And hopefully we have a whole number of you out there watching, because there are significant developments that have occurred over the last year or a little over a year regarding landlord and tenants' rights and responsibilities. As we tape this, we're still in the throes of the pandemic. And one of the big issues related to the pandemic was the economic issues. And that includes people not being able to work, not being paid, people being laid off because of the economic hit due to the pandemic. And as a result, there's been significant problems with people being able to pay the rent, questions as to what am I going to do, and then all types of different parties jumping in to weigh in on what should happen with evictions and that sort of thing. So we're going to go through this program talking about what the rights and responsibilities of the parties are. And as you get toward the end, when we start talking about evictions, that's where there's been a huge change, huge question marks right now as we currently sit. So I'll try to give you some guidance as to the lay of the land. As it presently exists, the understanding that if you are watching this after the date that we've been talking, which is September 10th, 2020, you should really check to see if things have changed, because they are set to change in October in some respects, and maybe not through the end of the year, depending on what takes place. So this is up through today, September 10, 2020. Things could change dramatically tomorrow or later this afternoon or October, November, December. So let's start by talking about some changes that occurred a little over a year ago. Back in June of 2019, there was massive legislation that took place affecting the relationship between landlords and tenants. The law was broken into 15 different sections. It was 74 pages long, and one section of it was entitled the Housing Stability and Tenant Protection Act of 2019. It involves rent control, and I know in a lot of the areas that we all deal with in the southern tier, central New York, there isn't rent stabilization. There could be, the way the law was developed, that communities counties could undertake, municipalities could undertake some type of rent controls and things, but most have not. It deals with leasing and notices to tenants and landlords, eviction procedures. So it really was all encompassing. Subsequent to that, when the pandemic hit, we've had Governor Cuomo issue executive orders. They were extended, they expired, the legislature stepped in and adopted legislation. The court system has issued court rules, and the federal government just in the last week has stepped in as well. So it's really, really all out there and confusing, even confusing to me, someone who does this all the time. So let's kind of start at the beginning, which is the whole lease transaction is the lease origination. When two parties enter into this agreement to rent property, and we will limit our discussion today to residential real property, not to commercial. The lease is actually just the agreement or contract between two parties, excuse me, the landlord and the tenant. By virtue of this contract, the landlord gives up exclusive use and occupancy of the apartment space. It could be the rental of a house, so the landlord gives up exclusive use and occupancy of the house. Or it could be a unit within a building where there's multiple tenant units in there, and that as the parcel, each unit is rented out, the landlord gives up exclusive use and occupancy of that property. And unless the landlord reserves any rights to enter the property, he or she does not have the right to enter the property except for an emergency on reasonable notice to the tenant. In consideration of receiving exclusive use and occupancy of the apartment, the tenant agrees to pay for that. And so the consideration given back to the landlord for the landlord giving up exclusive use and occupancy is the tenant's agreement to pay the rent. That's the fundamental basis of a contract. There's an offer, an acceptance, and consideration on both parties. So what happens is somebody makes an offer. It could be the tenant or the landlord makes the offer, say, I will rent this to you for X number of dollars. The acceptance is the tenant saying, I accept, and agree to pay the amount of the rent. So both parties have given up something or obligated themselves to something, and therefore a contract is formed. It can be oral for agreements up to a year. So the standard lease, I'm going to agree to rent this place for a year. It could be in writing or it could be oral, but I recommend that you do everything in writing. And I recommend that to the tenant and I recommend that to the landlord. Get everything in writing. The parties' rights and responsibilities can be defined in that written contract. And then if you cover all the bases in the written contract, there's no question later on about who's responsible for what if it's all written in the contract. If it's just an oral agreement, yeah, I'll rent this to you for $500 a month, and I'll rent it from you for $500 a month. Who's responsible for the utilities? Who's responsible for cleaning the sidewalks? Who's responsible for other things, maintaining the property, the outside of the property, that sort of thing? If the question gets raised, well, the grass isn't mowed. Well, who agreed to mow it? Yeah, I'll rent this to you for $500. Was the landlord? That's why it's really important to get a written agreement that sets forth all of these things so that there are no questions later on. So you could do it up to a year without a written agreement. It's just the contract, the oral agreement between the parties. I recommend that you don't do it. Now, another part of this is if the parties just agree and say, yeah, I'll rent it from you for $500 a month. It says, okay, you can rent it for me. How long is it rented for? Nobody knows, unless there's a specific agreement to that. But the law steps in there. There is actually a presumption that if not otherwise stated, the agreement between the parties is month to month. So that is for less than a year. So it could be done orally. You can have an oral month-to-month lease. And if it's not otherwise agreed upon, the law presumes that it is a month-to-month lease. So much better to have it in writing. So much better to have the specific term in it. The landlord could agree, the parties could agree, to do it month to month. That doesn't mean it has to be oral. It should still be in writing. You can just put in that it's a month-to-month lease in the written part of it, and cancelable by either party with 1 month's notice. So what happens with a month-to-month lease is you, in essence, have a new lease every month. And with regard to notices later on, the new Housing Stability and Tenant Protection Act actually has some provisions in it about the notice that either party must give to each other in order to terminate the lease. Under the old rule, it was either party could give 30 on a month-to-month lease, or a lease that expired. For example, if you had a lease for a year, but the tenant and landlord just continued it going forward, it doesn't renew for another year automatically. What would happen is if there's a lease that's for a term, a year, 2 years, whatever, when it expires, if not otherwise agreed upon between the parties, it automatically converts to month-to-month. And so the old rule was, when you were in the terms of a month-to-month lease, either party may terminate on 30 days notice before the beginning of a term. So we're here in September. So if parties were on a month-to-month lease, during this month, at the end of September, what would happen is that either party, if they wanted to terminate the lease, would have to give the other party notice that effective September 30th, the lease expires. So before September 1st, you give the 30-day notice, either landlord or tenant, and then the lease will expire at the end of September. That has changed a little bit, and we will get into that a little bit later. So, as far as the landlord the lease origination, the new law from 2019 steps in and provides some conditions that were not previously set forth in the law. And that is, one thing is, the landlord cannot refuse to rent to a tenant who is involved in a prior eviction matter. So the landlord cannot take that into account. There's a rebuttable presumption, meaning there's a presumption that if the landlord requests information from the tenant, screening about prior evictions, or reviews court records, and then refuses to, and saw in the court records that the person had been previously evicted from the premises. If the landlord refuses to rent to that tenant, there's a rebuttable presumption that he has violated that section of the law that says you cannot take into account the fact that the tenant had been had a prior eviction. It gives the Attorney General's office jurisdiction to sue, and there can be an injunction, which means there could be a court order saying, landlord, you cannot you cannot prohibit this tenant from renting from you, and there can be a civil penalty of anywhere between $500 and $1,000. So it can be pretty significant. So you cannot take into account that the tenant has been involved in a prior eviction when evaluating a particular tenant. Also, the landlord cannot take an application fee or administrative fee or some other type of fee except for a background or credit check, but no more than the lesser of the actual cost to get that background credit check, or $20. So it's no more than $20 can that credit check cost be imposed. Also, at the start of the lease, many of us expect to be a security deposit. I used to speak, if you saw the prior presentations that I've done on landlord-tenant matters, I used to always say, we've always expected to pay 1 month rent as a security deposit. But there was nothing that ever said that. So in the past, the landlord could take 2 months security deposit. There was no set amount in the law. That's changed. It's now specifically put forth in the law that the deposit can be no more than 1 month's rent. And that would also include a prohibition where someone collects the first month's rent and the last month's rent, because what sometimes you saw was, okay, the tenant has to pay the first month's rent up front. Fine, that's okay. Then they have to pay the security deposit. Fine. Then they had to pay the last month's rent. So they pay 3 months up front. No longer. The most the landlord can take is deposit equal to 1 month. Now, that raises a big issue for landlords because in Ithaca, such a large percentage of the housing stock is rental housing. At one point in time, there was a figure of somewhere in the neighborhood of 70% of housing in the Ithaca area, and a lot of it has to do with student housing. 70% of the housing is rental property. And in the particular case of student housing, what lots of times happened is landlords took a whole semester of payments up front for the rent, so you had to pay the whole lump sum. Under the statute, the most that you can pay as a deposit is 1 month's rent. So landlords need to keep that in mind. You can't take the whole semester, a whole year, school year worth of rent up front if you're renting residential property to someone, which could include a student. So just a proviso out there that you have to be very careful about this provision where the law says no more than 1 month's rent can be taken as a deposit. And I would say that unless you got anything paid over the current rent would be a deposit. It's to secure future performance under the agreement. That's not allowable under the statute. Late fees. Late fees are limited now to the lesser of 5% of the rent or $50. So the $50 a month, so it'd be $50, and it's the lesser of the two, lesser than 5% or $50. So $600 rent, late fee would be 5%, which would be $30. That's the limit. The maximum is $50. So if rent's more than $1,000, your late fee is limited to $50. Any provision in the agreement that tries to vary that is void, meaning unenforceable, illegal. The late fee cannot be charged until the rent payment is 5 days late. So you can't start charging the late fee at day 2 or day 3 of it being late. And also, under the current COVID rules, that late fee was suspended through August 20th. The landlord must give written receipt for any cash payments and must keep records for 3 years. So if you receive a cash payment, get out your receipt book and immediately give a receipt to the tenant. Inspections. After signing the lease, but before occupancy, the landlord must offer the tenant the opportunity to inspect. They will execute a written agreement attesting to the condition, so they can be used at the time of move out, and no tenant coming in can be charged for noted defects on that inspection report. During the term of the lease, the parties are bound by what they agree to. Landlord has certain responsibilities with the lease. One is the landlord must provide a habitable residence, and that means that it's livable, safe, and sanitary, that it has water, hot water, heat. There's no requirement that it have air conditioning. That doesn't come up to the standards of habitability. You can still live in it without air conditioning. It might be uncomfortable. There's no designation in the law that there must be. However, if the parties do agree that they're going to rent an apartment and the apartment has functional air conditioning in the apartment, if the air conditioning goes out, it could be a breach of the contract the parties entered into, because there's an expectation by the tenant they're going to have air conditioning because that's what was offered to them and what they saw when they looked at the property, but it wouldn't necessarily make it uninhabitable. The tenant's remedies, if the property is not habitable, are to, I'll just give you the list, then we'll talk about it. Withhold the rent, sue for a reduction in the rent, call code enforcement, because the standards for habitability are low. It has to be safe, sanitary, functional. Doesn't have to be the Taj Mahal. Doesn't have to have the newest carpeting or things like that. But it does have to meet this minimum standard. And one good measure for that is code. Code has certain minimum standards that must be met. So one thing that the tenant should do is to contact code enforcement to see if it is not up to a certain standard. It's also helpful because I know that Tompkins County has an active code enforcement office, and if a particular property does not meet code, they will then contact the landlord, and there could be financial penalties and things for landlords who are not keeping their property up to code. Landlords, understand this, you cannot retaliate against a tenant for calling code, for making a good faith complaint to code enforcement. A landlord cannot retaliate and say, try and kick the tenant out, not renew the lease. The law specifically provides that there is a rebuttable presumption. There we are, that term. A presumption. It could be rebutted by the landlord with proof, but it goes in with a presumption that the landlord is retaliating against the tenant if the landlord refuses to re-rent the property, starts an eviction proceeding, or substantially changes the lease terms within a year of the tenant making a good faith complaint to government, in this case code, for violations or enforcement of the tenant's rights under the lease. So understand that landlords understand that tenants are entitled to call code for good faith complaints. I don't have water. Call code. Code calls the landlord and says, look, you don't have water. You got to get somebody in there right away to check it out. And then if the landlord turns around and says, well, the lease is over within 2 months, I'm just going to wait it out and not renew the lease. There's a presumption the reason why the landlord's not renewing is because the tenant made a good faith complaint to code. So the landlord can be held responsible. The landlord is not necessarily responsible for noisy tenants, other occupants of the apartment building. Tenants, they should call law enforcement just like you would call law enforcement if you're the owner of a house and the next door neighbors are partying at 3 o'clock in the morning and you had to get up and go to work the next morning. What would you do? You call law enforcement. Same thing here. You should still also notify the landlord and inform the landlord of what's been going on, because the landlords really do want to know what's going on with the property. And if they have some troublesome tenants, they would want to do something about that. I've heard anecdotally that tenants may in the past have claimed that this was a breach of the warranty of habitability because they don't have quiet enjoyment of the premises. I don't know that any court has ever decided that particular issue. And as a general rule, the landlord is not responsible for the noisy tenants next door. Another thing at the inception of the lease is security deposits. Again, how we mentioned, it's limited to 1 month's rent. Understand, landlords, that any security deposit, any deposit paid by the tenant belongs to the tenant and remains owned by the tenant until it gets returned to them, so that there are certain rules with the handling of security deposits. One is the landlord cannot commingle the security deposit with his or her own money, meaning they can't deposit it into their own bank account. Landlords, you should set up a separate trust account, separate bank account that you can deposit all tenant security deposits, so that at the end of the lease, you can then just write a check or withdraw the money and hand it back over to the tenant, minus the damages or anything that occurred that would entitle the landlord to keep some of the money to pay for repairs. And because of our limitation of time, there's a whole host of new laws that went into effect regarding security deposits that right now I'm not going to go through with it, but landlords, notice that he or she is leaving at the end of the term and wants to leave during the term. Say that it's a 1-year lease and the tenant wants to leave after 6 months. The tenant is still responsible for the remaining term of the lease, but the landlord, whether notice or not, the landlord is required under the law to what is referred to as mitigate his or her damages. So that means the landlord, even though there's 6 months remaining on the lease, the landlord has to take reasonable attempts to find a new tenant. And the new tenant who comes in, if that tenant is paying at least what the prior tenant was paying, the prior tenant has no further obligation under the lease. Because the landlord's made whole then. The new tenant comes in immediately, pays the exact or more than what the prior tenant was paying, the landlord hasn't lost anything. So the law says the landlord must make those attempts. The landlord can't just sit there for the remaining 6 months ago, I got somebody on the hook for the remaining 6 months. If the landlord can't show that he or she has taken reasonable attempts to try to mitigate the damages, then the tenant will be absolved of any responsibility under the lease agreement. Any attempt to remove that mitigation obligation is void, so the landlord can't put in the contract, if you leave, you're responsible for the remaining term of the lease. I don't have to find anybody to fill your spot. That term is void, so it's illegal and unenforceable. Reasonable and customary attempts must be made to lease the property at fair market value or the current rent that's being charged. Again, just quickly, that when the tenant leaves, or prior to the expiration of the lease, the landlord must give written notice of a right to inspect the property 1 to 2 weeks prior to vacating the property. Reasonable notice is 48 hours, and the landlord must have an itemized statement of every defect that's in the property. And within 14 days after vacating, this is what I talked about earlier, within 14 days of vacating, it's a really short period of time, the landlord has to provide an itemized statement to the tenant of what damages or landlord forfeits his or her right to retain any of the deposit. Okay, now we're at the end, where people have to be evicted. The tenant holds over at the end of the term and the landlord wants him or her out, or the tenant has not paid the rent and the landlord wants to evict them. First and foremost, landlords, you can only evict by getting a court order. If the tenant has not left voluntarily, you can't do anything to remove the tenant other than go to court to evict. Bottom line, you cannot. It's a crime if you do. Turn off utilities, change the locks, harass the tenant to force them out. If you do anything like that, it is a crime and you can be arrested. It's as simple as that. As much as people don't like it, that's what the law says. And I know for a fact, because we've had conversations with law enforcement, they are arresting people, arresting landlords who are trying to self-help in getting people evicted who haven't paid the rent. So where are we in the status of evictions now? Because of the COVID situation and the terrible possibility that people could be left homeless, there have been various laws, orders, all different types of things from different governmental entities that have really changed the landscape as far as eviction goes. So what I'm going to try to do is tell you where we are today. Well, going back to when this pandemic originally hit and there were concerns that tenants could not pay the rent, the governor actually issued executive orders, which he extended several times, that prohibited the starting of an enforcement of eviction orders. So that landlords, even though they weren't paid, they couldn't go to court and get an eviction order, and the landlords could not force tenants to be out. So those executive orders were extended over a period of time. Well, they, as far as residential property goes, they expired, but they would have continued to go on with the governor signing executive orders, but he didn't have to do that because the legislature stepped in and actually enacted a law that says that no eviction actions may be started or evictions executed upon or enforced until such time as the COVID-19 pandemic had expired. So that's what the law says. Until the emergency expires, there are no evictions allowed. Well, when does it expire? Nobody knows. It's pretty much when the governor makes the determination that the pandemic has ceased to be effective economically and all that evictions can go forth. So there's currently a New York law. So the New York legislature has adopted a law that said until this declaration of the pandemic emergency expires, there are no evictions, executions, and eviction actions for those who have been financially impacted by the COVID. So the executive orders expire, but now there's a law in place. The legislature enacted if you want to look it up, Tenant Safe Harbor Act. And so no court can issue a warrant of eviction for residential tenant who has suffered a financial hardship as a result of the pandemic. And again, it goes until the governor declares that pandemic emergency is over. So that's the state legislature. Well, the court system has also issued a order. And the court rules are that evictions are suspended until October 1 of 2020. Maybe that'll get extended, we don't know. So it's kind of built on top of what the legislature enacted. The court rules now say no eviction executions until October 1, 2020. So we have the legislature, we have the court rules, and now we got something else. Last week, the CDC, so a federal agency, issued an emergency order. That's September 2nd, issued an order that prohibits landlords from starting non-payment evictions. So holdovers might be a little different, but non-payment evictions are prohibited until December 31, 2020. So you can't do it under federal agency order until the end of this year, but that's in certain circumstances and certain conditions. One is, and this is true with the state as well, tenants have not been absolved of the responsibility to pay rent. So tenants could still be sued for the amount of the rent. They just can't be evicted. So under the CDC's executive order, the tenant is allowed, the landlord cannot do an eviction if the tenant provides the landlord with a declaration that has certain provisions in it. This declaration is a sworn statement subject to a penalty, perjury penalty, because it has to be true, sworn statement. could subject the tenant to a $100,000 fine or 1 year in jail if it is not true and they sign it. So they be very careful, tenants, make sure that all these declarations are actually true. And one is the tenant must have taken their best efforts to obtain all government assistance available. In other words, if there's some type of public assistance, rent assistance, those sorts of things, the tenant must take all efforts to obtain and qualify for that assistance. It only applies to, the declaration says that the tenant must expect to earn no more than $99,000 in annual income, which would amount to $198,000 for those filing joint tax returns. A husband and wife will file a joint tax return. If they have to swear that they are not going to be earning that much money, or that they are not required to report income. They were not required to report income for 2019. And the only times that we're not obligated to not report income is if our income was so low. You would have been below the $99,000 standard. Or that you received a stimulus check under the CARES Act. And I know many people have received a stimulus check. So if you received a stimulus check, you would qualify. You put on the declaration, yes, I received a stimulus check. And that meets that qualification. So it's either you haven't earned more than $99,000, you weren't required to report income in 2019, or you received a stimulus check. The next thing is you must declare that you are unable to pay the full rent due to a substantial loss of income. Due to the pandemic, you lost your job, you had your hours cut, it was a substantial loss. You must declare that you are using your best efforts to make timely partial payments. So based on your circumstances, let's say your rent's $1,000 a month, and because of financial circumstances, let's say your hours were cut back. So you could swing $500 a month. You've got to make the $500 payment because you have to declare that you are using your best efforts to make a timely partial payment. The next thing is that you must declare that your eviction would be likely to render you homeless or go into a congregate setting. Congregate meaning joint living arrangement. Like you have to go. A family has to go live with elderly parents because they're going to be homeless otherwise, or they have to go in a public housing, multiple dwelling unit, living together with others because of that. So you have to declare that the eviction would render you harmless, or that would put you into a congregate living setting. I think the rationale behind that is that we don't want additional spread of the COVID virus by putting more people all together. So you must supply that declaration to the landlord. Also, if they're joint tenants on the tenancy, both tenants must sign a declaration with those terms in it. If you do that and furnish it to the landlord, one, you could furnish it to the court if you're in the middle of an eviction proceeding, or you could furnish it to the landlord now. Then under the CDC emergency order, the landlord is prohibited from pursuing an eviction proceeding. There's all those things stacked upon each other, and some may expire, others may still be in effect. So you really have to sit down and consider what the different eviction suspensions are in place in order to figure out your way through that. Kind of going back to the general terms outside of pandemic, just generally is that this is true at all times, pandemic or no pandemic. And that is The landlord cannot use self-help to throw a tenant out. That is completely prohibited by the law. It's a crime. The landlord must go through and get a court order. And in a lot of instances, the landlord can't get a court order right now. And that's in the unfortunate circumstance, but that's where we're living right now. Landlord may not use self-help. That includes cutting utilities, changing locks, harassing tenants. And the statute says engaging in a course of conduct that interferes or intends to interfere to disturb the occupancy. So I've heard horror stories over the last 6 months of what some of the landlords are trying to do. You may not do that. And like I said before, we're hearing about situations where landlords are actually getting arrested and having to appear in court for misdemeanor charges. It's a Class A misdemeanor in the civil penalty and could be subject to a civil penalty of anywhere from $1,000 to $10,000 for each violations. So, some landlords are getting cute. They're trying to disturb a tenant's occupancy, where I heard in one instance where a landlord was parking his dump trucks in the driveway of the tenancy to prevent the tenant from parking there and making the tenant park way down the street in a parking lot or something. That's interfering with the tenant's use of occupancy. If that driveway was a parking space for the tenant, you got to keep the same level of occupancy in the premises while you go through this process. You just have to, we all have to live with it. I've heard of landlords going into basements and shutting off breakers. You can't do that. It's a crime. So, word to the wise, you can be arrested for this. So, act accordingly. Now, in normal circumstances, again, outside of a pandemic, and there's been a failure to pay the rent, and there's not all these suspensions and procedures, there's certain things that the landlord must do. And if the landlord doesn't do it, the eviction matter is going to be tossed out and the landlord has to start again. So really understand what the obligation is. One is that the landlord must give the tenant a 5-day reminder notice. So rent hasn't been paid for 5 days, the landlord must give a notice, hey, your rent's due, it's more than 5 days due. And you remember when we initially talked about it, late fees can't kick in till the 5th day. I put in the notes too, the late fees up to $50. It's 5% of the rent. Just, you need to get it paid. And after that 5-day reminder notice has been given, the landlord must also serve a 14-day written demand for payment or vacating the premises. In the olden days, it used to be a lot shorter notice. 7 days they had to give. Now you have to give a 14-day notice to pay or get out, separate from the 5-day reminder notice. Then after that 14-day period of the notice to pay or get out, the tenant must be served with a notice of petition and petition to appear in court. And the notice to be in court must be no less than 10, no more than 17 days from the day the notice is served. So you have to figure out when the court date is, count back 10 days, count back 17 days, and in that window, the papers have to be served on the tenant. If you don't do that, then you don't meet the standard to get an eviction, and you go into court, and the court has to throw it out. Then at the return date, so when you go into court on that day that's listed on the notice of when you have to be there, that either party, tenant or landlord, can ask for an at least 14-day adjournment of the proceeding to prepare the case. So it can extend out another 14 days or more. Then you come back into court, and if the court determines that rent hasn't been paid, it was due, there's no excuse, the court will issue what's called a eviction warrant. That eviction warrant must then be given to law enforcement. So it's usually the civil division of the sheriff's department. There used to be a time when cities had city marshals and town constables and things. There's less of those now than there were before. So it's usually the civil division of the sheriff's office. The sheriff has to go out and serve that notice with another 14-day notice that says you have to get out within 14 days based on this warrant that you sign. If you don't leave the premises at the end of 14 days, we're going to be back and we're going to throw you out. This new process from start to finish can take a month and a half, if not longer, depending on when you can get in court. It's called a summary proceeding for the recovery of real property. With all these time periods, it's becoming less summary and more of an extended process, but that's the way that the law is. Also, rent can be paid by the tenant up to the date of the actual execution of the warrant. When the sheriff comes back and says, okay, I'm throwing you out now, if the tenant pays the rent up to that day, eviction stops and the tenant is allowed to stay. Unless the landlord can prove that the rent that had not been paid was being withheld in bad faith by the tenant, which would be a kind of a high standard to meet. But if they could show the tenant was just being executed in bad faith, not paying the rent just because the tenant was being a jerk or something, not paid it, but always had it, and if the landlord could prove that, then the landlord can say that you're still getting out. Tenant can make an application to the court to stay an eviction for an extreme hardship, but it's that stay will only be granted by a court in certain circumstances, extenuating circumstances, after proof of showing an extreme hardship, and that it will be granted with certain payment terms that have to be met. The landlord also can only get a judgment for the base rent during an eviction proceeding. So late fees, other expenses can't be obtained except by the tenant or the landlord suing the tenant in a separate proceeding, not the eviction proceeding itself. To get those extra monies, the landlord has to do a separate case to sue for the extras. They can only get the base rent during an eviction proceeding. During an eviction proceeding, the landlord can sue to have the tenant be evicted and to get a judgment for the amount of the rent. The problem is, for the landlord, they can only get the base rent. They can't get late fees. They can't get collection costs and things like that. So that's an eviction for a tenant who hasn't paid the rent, a failure to pay rent eviction. There's also evictions for holdover tenants, meaning tenants have stayed past the end of their term and the landlord wants them out. The procedures that we've talked about are generally the same. Obviously, you don't need the 5-day you haven't paid rent warning letter that we talked about originally, because it's not a failure to pay rent situation. It's living there past the extending portion of your term. So that's it. I'm past my time. I haven't covered everything. I do encourage people to check our website at ag.ny.gov, and at the very top, just below the banner, there's a big blue printing about COVID-related issues. I'm actually looking at it right now to get what it says. It says, it's in big letters, notice, guidance on coronavirus resources and warnings about consumer scams. If you click on that link, you go to a page and it'll talk about different issues, and you'll have a link to select a topic. And one of the topics is tenants' rights. And inside the tenants' rights, there's these all kinds of FAQs, for lack of a better term, about different questions that you might have, and there are answers to all the different questions that people might have. A lot of the things that we've talked about today, but there'll be others that I didn't get a chance to mention. So with that, let me first hand it back to Kenneth. Kenneth, did we get any questions along the way?
We did not. We did not get any questions, unfortunately, but we did have 30 people who tuned in to watch it. So I presume that you were effective in your presentation and you answered all the questions that people had.
Or I confused everybody so much they wouldn't even know what questions to ask.
Well, thank you, Mike. I appreciate it. Well, everybody, thank you for tuning in. We will be here the second Thursday of every month. Um, if you have any questions, you can always contact the Attorney General's office directly. The Binghamton office email and contact information is on our website as well. And also, you can contact us directly at ccetompkins.org, ccetompkins.org, yes, online. Thank you very much for tuning in, and thank you, and have a great day.
Thank you all.